The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning. I am Stuart Address, and it is Friday the 13th, and I'm terrified. I really believe in that superstition. I've had several things happen to me on Friday the 13th. I've bent down and had a watch fall off my hand and break, and a few other things, so I'm very careful today. I don't know about you folks out there, but I'm pretty careful. Anyway, I am happy about the fact that a number of you have been calling my office of late and asking a lawyer about whether or not you might have a case. We appreciate that. We're representing a couple of you, and we appreciate that even more. But for those of you who think you might have a case, this is a great opportunity to bypass Ask a Paralegal and get straight to the lawyer. So give us a call on any topic. If it's an area that I can discuss with you, for example, I don't know much about criminal defense or foreclosure.
We can still talk about it,
we
though,
could
right?
try. Yeah, I'll try not to fake it too much. But, give us a call. Ask me about it. Let's chat about it. You never know. You might find that it's a good idea to maybe call my office or somebody else's office and pursue it further. Or you may decide that maybe there isn't something there anyway. So it doesn't matter what topic we're talking about today or any other day. Just give us a call no matter what. And for those of you out there, for example, who have called my office, or those of you who may be thinking about calling my office, call the radio show. It makes for a much more lively hour. This way you don't have to listen to me go on and on and on.
No appointment necessary.
That's right. As many of my professors used to say, an exchange, a dialogue is much more interesting than having somebody, lecture at you for an hour. So, talk to us. Anyway, we were talking last week, finally, about sexual harassment.
That was part one.
That was part one. There could be parts 2, 3, 4, 5, and 6.
See how long this goes on, right?
But we'll see whether or not we finish that today and go on to another area. We talked about the requirements generally. You have to have 15 employees, for Title VII of the Civil Rights Act or the Florida Civil Rights Act to apply. And we've had people call us with interesting conundrums. Well, they only have like 10 employees. But they have 20 independent contractors.
Amazing. Wonder why that is.
Well, and we say, well, tell me about those independent contractors. Mm-hmm. What do they do? Because very often, independent contractors are not really independent contractors. They're misclassified, as we talked about in the wage and hour sections.
Yeah, they're employees that are not on the
right.
books.
And if that's the case, the employer may really have 15 employees and may be covered under the Civil Rights Act, and you may actually have a case. These are the types of...
Those independent contractors may have cases, too.
That's right. And they may have different types of cases.
Yeah.
That's right. These are the types of nuances that sometimes you really do need a lawyer to answer. Because you may think there's no way, and you talk to a lawyer and you give out the facts, and a lawyer says, oh, the red light goes off in the head. All right, we have our first call already on line one. It's Marty. How you doing, Marty?
Yeah, good morning. How are you today?
I'm very good.
Service. An issue I have, I took my boat into a local dealership for a maintenance issue, and I signed the invoice agreeing how much time it should take to make the repair. However, they now want to double that after the fact, which is several $100s. The manufacturer specifies the time allocated to make the repair, but the dealership has doubled that. Where do I stand short of them keeping my boat hostage if I don't want to agree to those terms?
All right. Now, what is it exactly that you signed? Was it an estimate or was it an invoice?
I don't know exactly the terminology, but he predicted the time that it would take, and I agreed up front. I signed that. And after they got into the job, they determined that with their capabilities, it would, so they say, take twice the amount of time. But the manufacturer has a technical guide that says how much it will take to do the job.
All right, and
so I'm asking them to stay with the manufacturer's guidelines.
Well, that seems to make sense. On the document you signed, whatever it's called, do you know whether it says that there's an estimate that it will cost X amount of money, and if it goes beyond, let's say 20% above that, your written consent is required? Or do you know what it says? Because that's what the first thing a lawyer's going to look at.
No, I just agreed to the fact. He told me that it would take a specified amount of time. I agreed to that, and I signed it and turned the boat and keys over to him.
All right. Well, if it's that cut and dried, honestly, then you probably would have a claim. If he's saying it's going to cost this amount of time, and now it's going to cost double, and that double is beyond what even the manufacturer says is the time required for the work to be performed, then you very well may have a claim. Getting your boat back obviously is tough. You have a couple of choices. One might be to pay for the work that is done so far and then go after him after that in small claims court.
I'm trying to avoid all that up front. I'm just trying to be civil and say, look, this is what the manufacturer says. I don't know how you could justify doubling that.
Have you put anything in writing to him? Has it just been phone calls?
Just been phone calls. He's been very nonchalant about giving me the exact time, other than exceeds what he originally quoted me.
All right. One of the things I suggest to people who do call my office is the magic of putting things in writing and making a record. I would put in writing, nothing extensive, but I would put in writing exactly what you've said.
Is an email just as good?
Email is just as good because you can show it's been sent. Fax is just as good. These days it doesn't have to be certified mail, return receipt, overnight mail. Yeah, email's great. Faxing is great because you get that little confirmation. But I would put it in writing very briefly. I agreed to this price. This is what you said it would, how long you said it would take. You're now trying to double it. That seems odd to be given the manufacturers, whatever the information is you have. I don't agree in paying that additional amount. Either honor the agreement and return my boat in prepared condition, or I'm going to consider a number of possible claims against you. And what I would put in an email is breach of contract, fraud, unfair and deceptive trade practices. Those are types of things that maybe upon receipt they get it and they say it's not worth it to play games with this particular customer.
Well, let me ask you, should I put it on my credit card and use the credit card charge?
No, you can't actually do that. If you put a charge on your credit card knowing that you're going to dispute it, that could be construed as theft on your part.
Okay.
So I would really start out with an email that is, clear about the facts and just a few sentences. Mention breach of contract, mention fraud, mention unfair and deceptive trade practices. It's actually a statute, which is why the wording is so long.
Right.
Anybody who does business will know what that means. And you can mention that, if you have to sue them for unfair and deceptive trade practices, if you win, you get attorney's fees.
Oh, really?
So
I'd have to find someone. Okay, yeah.
Yeah. So that may get them to decide you're not the one they want to play games with. Let them do it to somebody else, unfortunately.
Okay. Thank you for the information.
You're very welcome. Good luck.
Your service there. Bye-bye.
Take care.
Would this be the type of case you would handle in case his letter doesn't do any good?
Yes, it would. A lot depends upon the amount in controversy because sometimes it's not cost effective. There are situations, particularly when you get to boats, where you could be dealing with tens of thousands of dollars, and usually in my office, we don't open up a file under $1,500 as a retainer, unless it's a contingency fee type case. And so whether or not that type of money is worth it, very often I tell people, I don't really think it's worth it. I think you should try this first.
Okay.
You can do it on your own first, maybe save having to pay me, and then be so happy that I was honest with you and saved you the money, that maybe one day, 5 years from now, something really happens and you remember and you come to me.
Right.
I'd rather make the money that way.
Or you tell a friend.
Tell a friend. And we just had that happen, actually. Wonderfully had that happen.
Yeah, this boat situation seems like one of those deals where you get the job, and well, you've landed the job, and you have the boat in your yard, and you go on to do other work.
Right, and sometimes the other work, honestly, is necessary. But then the proper practice would be, to submit a change addendum. It's similar when you bring your car in for servicing or for repair. Generally, I'm not as familiar with Florida law about boats, but when it comes to vehicles, you have to sign something that says this is the estimate you've been given. And in the small print, it says either you're giving your consent that they can go over by X percentage, or you're saying, no, you have to sign another invoice before they do additional work beyond that amount.
Or at least give me a call before we do anything more and let me know that it's going to be a little more.
Absolutely. So that does happen a lot. People get surprised. And sometimes, look, there really is additional work that needs to be done.
They gave you their best guess as to what it would be, and then they found something else.
Absolutely. So that's something that is a legitimate issue. And unfortunately, what I have found, the lawyers are trained to be pessimists. You're trained to doubt everything and question everything. Sometimes it's somebody just trying to jerk you around, and a smart document in writing that the other person knows is a record now gets them to back down and figure, well, I'll deal with somebody else when I want to make money. And sometimes it really is innocent, and you can't really tell until you try to resolve it, and if verbally doesn't work, you put it in writing. And then, if necessary, it goes somewhere, and it's not just he said, she said. So that's the way that works.
Documentation.
That's right. So in terms of the sexual harassment, we were talking about, independent contractors. A lot of them are often employees. So don't just give up because you're in a place and you're being brutally sexually harassed. And there's eight employees, but let's say it's it's a stone cutting company, and they have all these field workers that are independent contractors. You may not know, it may not be improper, but it's a good idea to ask a lawyer and find out whether or not there is a way to get around the 15, because maybe they really do have 15. Now, I was briefly beginning last week talking about just some illustrations of sexual harassment cases that we have handled. And honestly, they can be as varied as one comment, which may not satisfy the elements of the test, to rape. I mean, it runs the gamut. It really does. We had a long time ago, maybe a decade ago, more than a decade ago, a case against Publix that involved the deli department. Now, there are lots of things that can be used in a deli department that can be sexually harassing, like a salami. You folks figure it out for yourselves. And the deli manager was a woman, and the two subordinates who were being harassed were men. And that time, 12 years ago or so, it was not believed that men could be sexually harassed. This was just a thing that happened to women. But the law has become quite clear since then. It is not really a gender situation when it comes to sexual harassment.
Well, her actions were making them uncomfortable at work.
It's a power situation.
Okay.
So the supervisor, has power over the subordinate. And that can create any number of a type of situations, including sexual harassment. So we had a case where, I think I mentioned last radio show, or maybe it was after when we were off the air, where we had a client who was involved in a consensual relationship with her boss, which is not really a great idea. And it went a little bit too far, and she said no, he wouldn't stop, and he was spanking her, a little bit of S&M. And she got home and took some photographs of her buttocks, purple, lots of big bruises. Well, when a demand letter was sent to that employer with the photos in full living color, that case settled relatively quickly. We've had cases that involve sexual harassment in auto dealerships, the type of position that the woman is in, or just generally how they're treated. Same thing when it comes to a car wash. Where maybe the women are asked to dress in a different type of manner than the men in the same position, and it's designed to entice the customers.
So the outfit might be good for tips.
Exactly.
Or,
And yes,
yeah.
that's right.
Okay.
Anyway, we have Binky on line one. How can I help you, Binky?
It's about certified mail. I came to another house of mine and looked in the mailbox, and there was the yellow form. So I signed it. My friend saw me put it in the mailbox, and the mail carrier went right by it and didn't pick it up, even though she looked at it. So I signed it, put it back in the mailbox, and then I was at the house a couple days later and stopped the mail person, and she did not have it. She says, I have to have it, and then signed the green letter. This
Right.
is ridiculous, don't you think?
Yeah.
People will never, unless they camp out in front of the house, be able to pick up their certified mail, and I'm in a position I can't find this letter, and they might take my house for some reason. What do you think?
Well, I think that when it comes to certified mail, usually the first notice says what you just said, that, sign it, put it back in the mailbox, and they'll redeliver, usually in a day or two. Usually the next day the postal carrier has to come, get it, bring it back, and then you get your letter delivered the day after. Sometimes, depending upon the way the certified letter is sent, there may be a requirement, and a box will be checked on the form, that you have to actually pick it up. I don't know, which one yours was or how it looked, but
It was
if you're
the one where they have to deliver it in person. I have to be there and sign it. But right now, I don't know where the certified letter is. Nobody at the city who sent it knows where it came from.
it would be at your local post office.
But, sir, I don't want to drive to my local post office. It's kind of like I got better things to do.
And I really do appreciate that, and I would feel the same way. Unfortunately, it's not going to create a legal claim, especially with the post office. It may be best to call the 800 number for the U.S. Postal Service and let them know what's happening. They can get you in touch with your local post office, and very often you'll be able to speak directly to the postmaster at the local post office.
Well, sir, let me interrupt you. I called the phone office, the local post office, 13 times. All I got was what their address was, and then they put me on hold, and I never got through to them.
Well, that's what I would suggest. I'm not sure how else to help you other than to say, even though it's not fair, to go pick it up.
Oh, I can't do that. All right, thank you, sir.
I'm sorry. Bye-bye. I think we have Norman on line 2. Norman, you there? Norman, are you there on line 2?
Oh, yes, Norman.
How can I help you?
Yes, I'm just shut my radio down.
Yeah.
Okay.
Yes,
We are in delay, and you need to listen on the phone then, Norman.
okay, yeah, well, I just shut the radio down.
All right, great.
Yes, I have a motorhome that was, they finally totaled it. It was damaged during the hurricane.
Okay.
The branch went through and soaked it. And I thought I had an agreed value price. I've been paying on $90,000, and I've got way over 100 in it. And they turned around and says, no, it's got a little clause in it or less.
What do you mean,
Well,
a clause in what or less?
It says insured for $90,000 or less.
Okay.
And so we've been going round and round. I produced my bills, and I sent off to an appraisal in California, which come back at 65, and they want to give me 50.
Okay.
And,
okay. They want to give you, the insurance company wants to give you $50,000 on $90,000 in damage. Do I understand that correctly?
The damage, they wrote up an estimate when the insurance adjuster came out to my house. of $7,500. So he didn't know what he was doing.
Okay.
And then
And
they
now
came
they
back
told me
and
to take
totaled it?
They came back and they told me to take it to a shop that does. This is a Prevost bus that's
Okay.
converted by the converter, and they told me to take it to a place. So I went up to a place up in Sanford, and they paid for the toll up there, and it's been up there since September.
Well, in Sanford, did that agency say it was a total loss?
Yes,
All right, and
but they want to give.
go ahead.
They want to give me less money, and then now I'm dealing with somebody in California, in Ohio. He's a head, and
All right, let
we had
me interrupt you for a second. When they told you how much money they want to give you, have they sent you a document that lays out the basis for their evaluation?
yeah, they said that they had somebody take an average, because there is no blue book on these high-end motorhome conversions. And so I went and got an appraisal, and he came back low, but he made a mistake on the year. He put a 95 instead of an 85, and I sent them all the most of my bills that I could salvage that weren't soaked,
Right.
water soaked, and I says, you're trying to scam the senior citizen. I'm 80 years old.
Okay.
I'm going to be 81 soon. Now, is there a law against them trying to scam the senior
Well,
citizen?
I don't think it's going to fall into that, honestly. I don't think what they're doing is a result of you being a senior citizen, but what they're doing may or may not be, proper anyway. The insurance policy you took out, do you know whether it was for depreciated value? How they indicated the valuation would be done?
Well, that's what they said. It's of depreciation. But what happened was I have an umbrella policy with a company. I don't know if I can mention it, but
You can mention it, and I'm familiar with umbrella policies.
okay, it's USAA.
Okay.
I'm a veteran, and they recommend. Well, I had Progressive since '94. I've been with them, but with an agency down in Fort Lauderdale. Now they, when they did the umbrella policy, since USA uses Progressive, they had to reconvert the policy, and the guy asked me, "How much do you want insured for?" I said $90,000, and I assumed maybe my fault, but I assumed that it was a agreed value.
No, that's never the way it works, unfortunately.
Yeah.
You can insure something for any amount, but you're only going to get the value of the item with the loss. Now, there are different ways to calculate a loss depending upon the type of contract you have. I mean, there's actual cash value, there's depreciated value,
Is there replacement
there's
value?
replacement value. So any lawyer, frankly, to help you further is going to need to see the actual insurance policy to determine what type of a policy it is. And, those things, it's not very expensive. Some lawyers will offer free consults for things like that. Most lawyers, since it's not, personal injury, products liability, the types of things you see on TV, usually, in my office at least, those are paid consults. But, it may very well be worth it to have a lawyer look at your insurance contract. I've looked at many of them, and very often you're right. The insurance company is trying to just get away for less. It's
What
not
about an
uncommon.
independent insurance adjuster?
Well, that helps. But then if you hire an independent insurance adjuster, that person's going to take X percentage of whatever you get, just like a lawyer.
Or he's going to tell you that he can't take it because of the amount that would be recovered.
He might, but then again, some might take it just to get the percentage.
Okay.
Now, what is this? How does it work when you sue your own insurance company? One of the sidewalk lawyers was telling me that the insurance company has to pay for the lawyer's fee.
If you prevail, that is correct. If you sue your own insurance
if you
company,
prevail.
it's called a first-party lawsuit, and if you win, the insurance company has to pay your attorney's fees. But before you're ever going to sue your insurance company, a lawyer is going to have to determine that he thinks or she thinks you have a good case, especially if they're not taking it on an hourly basis. And so, again, they're going to want to look at the insurance contract to figure out exactly what type of an agreement it is and what type of a claim you may have and how you should proceed. And very often then an attorney is going to do a demand letter to the insurance company once he or she understands exactly what type of an insurance contract you have. I mean, you can feel free to call my office if you want, give my paralegal a lot more facts, and, we can see if we can help you. And obviously, I don't want to ever tell people they have to call me. You can call anybody, but we're certainly willing to listen to you.
Okay, because what they're doing is they're sending a independent appraiser coming over from Tampa.
Okay.
And let me see what they do with that, how he comes out with it.
All right, makes a lot of sense.
Okay, thank you.
You're very welcome. You take care and good luck.
Right, thank you.
Bye-bye.
340-1590, the number here at the station. Ask a lawyer.
Good questions. I mean,
Yeah.
it pays to ask. You don't know, and sometimes this happens a lot in my office. We'll get a whole fact pattern, and the answer will be dependent upon what does the document say, what does the contract say, what's the employment contract say, what's the non-compete say, what's the insurance contract say, and we can generalize about what is in most of these types of documents, but there is absolutely no way to give anybody real advice that's tailored to them unless you review the documents. And that's just what's
Which probably 99.9% of the people who signed those documents didn't read the whole thing anyway.
That's true, and you probably didn't have much choice in signing it because they're form documents.
Yeah.
But at least if you've read it or understood it, you know what kind of insurance you're bargaining for. Happens all the time when you buy a new car. I know the last car I bought about 7, 8 months ago, I read every document. And it annoyed them to no end.
Yeah. You're like,
As
we're
sitting
selling
there.
a car to a lawyer.
Yeah, I was able to skim a lot of it because it was familiar to me.
Sure.
But there were a few paragraphs and a couple of the documents I didn't quite like, and I challenged them. All righty, here we go. Oh my goodness! After a little vacation, a hiatus, I hope you had a really great time in a place like Hawaii. We got Bulldog on line 1.
Hey, Stuart, how are you?
I'm doing good. How are you?
Sir, can I get totally off topic?
Absolutely, anytime.
Right. I'd like to go into sexual harassment because you haven't covered that very much. And, it just triggered something. And I wanted to ask you, because I'd run into one of these, but when does email between coworkers cross that borderline? Because, I had a situation where dear and honey and things like that were being used, and obviously those are not appropriate. But when does it cross the line into where you consider it sexual harassment? Because the sensitivity level is very high right now, and I'm not sure where it is now as to where it has been.
All right, you're correct that the sensitivity level is heightened right now. It actually wouldn't change the law as to whether somebody would win or lose, but it could change whether or not an employee decides they want to try to pursue it. Email, it's not going to matter. Whatever it is going to matter, whether it's verbal and writing. The email is not the issue. The honey and dear really are terms that can be viewed as sexually harassing or terms that can be viewed as endearing. And it really depends in that situation on who is saying it and what their intent is, and whether or not the employee has said, I really don't appreciate that. I don't want you to call me honey. I don't want you to call me dear. Now, even if it's meant in a perfectly innocent way, if the employee has said, I find that offensive, then that person needs to stop. And if he doesn't, and it's reported to, higher ups in the company and they don't do anything about it, then the employer may very well be liable for a sexual harassment claim. You're right. It's sort of like there's no fine line, no fine definition of what is or isn't sexual harassment. It's like the Supreme Court justices have said with obscenity. I know it when I see it. Doesn't really help lawyers much, but the Supreme Court seems to be okay with that test for obscenity.
I know, and if you're in a corporate environment, you're looking at this, there's no fine definition as to say, because one person may be offended by something that would not offend another person, or they'd shrug it off, or just, punch the guy in the nose or something.
And that's why you tend to look, the cases tend to look at whether a reasonable person would be offended in that situation or could be offended in that situation. So there's a reasonable person element and there's a subjective element.
You mean not everyone's feelings matter?
They may matter. They may matter a little bit less depending if you're on the borderline. For example, my office. Okay, if all I had was somebody calling me and saying, "They're calling me dear and honey," I've told them I don't like it.
You'd say, "Deal with it, sweetie."
No, I wouldn't say that. I would say,
kidding.
You might have a claim, but it's not the kind of claim my office is going to handle. It's just not. It's not clear cut enough. It's not strong enough.
Do you say, "Why don't you try telling them just my name is whatever and call me that instead"?
Well, absolutely. I
Okay.
mean, there's nothing wrong with correcting somebody, even if they don't have any bad intent. They're probably going to take the correction gently.
Right.
If the intent is malicious to malign you by calling you honey all the time, where somebody in your position that's a male is called Mr. Jones and you're honey, that's sexual harassment. That's gender-based discrimination.
Could you be honey because they don't remember your name?
Well, then could you be Bud?
Yeah.
Or Buddy?
Yeah.
But no, you're exactly correct in that. And there are several cases that I've run into that just because of that, he knows his secretary's name, but he calls her honey anyway.
And if he was born in the 1930s, I might understand, but then he still needs to be counseled. And, depending upon the size of the company, there are lots of law firms these days that go into businesses and provide sexual harassment training. And people laugh at that, particularly when you see it on TV. But it's not always a bad idea, depending upon the size of the company and whether or not you've had claims of sexual harassment before. Sometimes the people on the front line, the supervisors, the managers, they may need to be refreshed a little bit about the law because they may cause employer liability. And that really gets us into, Bulldog, exactly the issue of complaining, which you've got to complain. I have too many people, and sometimes I really feel for them. They call my office and they say, "This is what's happening," and it really is sexual harassment. There's no doubt about it. And I say, "Well, have you told the person to stop?" No. Have you told them you don't really appreciate it? No. Have you complained to Human Resources? No.
What if there is no Human Resources
Have you complained
department?
to the owner?
Okay.
No.
Oh, wait a minute. Right, yeah. And Veronica is correct on that because you, as you also discussed, you are a contract employee. Do you complain to your contracting company or the company that you are contracted to?
You like to make me switch gears a lot, don't you? Okay.
Oh, yeah.
All right. You complain to both, frankly. If you're a contracted employee, let's say from a staffing agency, you complain to your primary employer, which is the staffing company, who is supposed to then take that and go to the contracted employer. But you really should also complain to the employer that you've been contracted to following its policies and procedures, because then there may be a sexual harassment claim against both the contracted employer and the staffing employer under a dual employment doctrine.
Oh my. Okay. That's a little over my head right there. I sort of remember that, but I didn't know that because half the time you work for an out-of-state, and I didn't know that the state laws would transfer.
Well, it's the federal law that transfers.
Okay.
The state law may be different. Instead of suing under the Florida Civil Rights Act, maybe the applicable act, depending upon where you're working and where you're doing most of your services, maybe it's the Illinois Civil Rights Act.
Oh, let's hope it's not Illinois.
Oh no, not
But the
Illinois.
federal act is going to apply. The federal act is going to apply no matter what. Title VII of the Civil Rights Act is going to apply. Whether or not there is a corresponding state statute is up in the air. Depends upon the state.
Right. Okay, I
All
got
right.
you. Well, thank you so much.
You're
and
welcome.
I'm sorry to take you off track like that.
That's all right. It's you keep that most mental wheels greased. Take care, Bulldog.
Have a great day, sir.
Okay, I will. You too. And so, really, folks, when it comes to complaining, these people who I've given the example who say no.
But were they afraid they would be fired
Okay,
if they
well, that's the
complained?
next question I
Okay,
ask.
okay.
Okay, why? And the answer is almost invariably the same.
Mm-hmm.
I'm afraid about my job. I need my job. I got to support my kids. And there was a time when that was an acceptable explanation. That time was more than a decade ago.
Mm-hmm.
The Supreme Court decided 2 cases on the same day, just after my Publix lawsuit. One of them is called Faragher, and it comes out of a lifeguard situation in Boca Raton. And the other is called Ellsworth. And so jointly, lawyers refer, when they're writing legal memorandum briefs to the court, as to the Faragher and Ellsworth doctrine.
Okay.
And it says the Supreme Court decided we are not going to hold an employer responsible unless you have followed appropriate procedures, if they exist, to complain, or if there are no written procedures, unless you've done the best you can to complain to somebody who may have the ability to fix it. Now, if your manager is sexually harassing you, you should still say no, but you don't stop there because the manager may not stop. You've got to go somewhere else. If you're in a company that has an employee handbook, I guarantee you these days there's a section on sexual harassment and discrimination. And if it says you need to, report it to your next higher level supervisor, then that's what you need to do.
Mm-hmm.
If it says you need to call human resources, that's what you need to do. If it says, like some larger companies, you need to call this 800 number, that's what you need to do. Because what the Supreme Court determined in those cases is that, well, we understand the concern, the reticence, generally again, of women, of reporting these types of things. We will not hold the actual employer responsible unless the employer has had a reasonable opportunity to investigate and take prompt remedial action.
Mm-hmm.
If not, they have an affirmative defense to liability, and they will win. Now, does that mean you can't hold anybody responsible? No. You can hold the co-employee or the supervisor responsible, not for sexual harassment, because that only applies to the employer. You might be able to hold them responsible for a battery claim. But let's be realistic. They may not have a lot of money. It's the deep pocket is the employer. And you want to be able to go after the employer in a situation like this. Now, I will tell you right now, this very moment, I have a case like this. And yesterday I was on the phone and an email with a client badgering her, you've got to let me draft an email for you complaining. I can't do that. I can't possibly go back to this job the day after. Everybody's going to look at me. Everybody's going to say things. I'm afraid how I'm going to be treated.
Well, at some point you have to be a grown-up.
Okay, but it really depends upon what's happening to you. Okay? So I said to...
But it's one or the other. You want to resolve this problem or you're just going to live with it.
In many cases, yes. So what I said to her is, if you're determined that you will not go back after notification of a complaint, then at the very least, let me try to get you within the protection of the statute. And arrange to take some personal time off, and then the day prior to you taking it, you send the email that I prepared for you.
Mm-hmm.
And then if by the time you're ready to come back, they haven't contacted you about an investigation, then you let me send another email saying, I can't possibly return under these circumstances.
Right.
You haven't done what you're supposed to do.
So you're giving your boss also a chance to
Right.
correct the problem.
And so you're at least I can make the argument then in front of a jury that we complained in the best way possible under the circumstances. We gave some reasonable period of time for the company to contact us, and they didn't. What happens if you don't do that? You're not 100% dead in the water. You're 90% dead in the water. A lot of lawyers like me may really not want to take the case if you haven't complained. There is an exception that might allow you to still pursue your case and prevail, even without the complaint.
Now, this person also may be afraid of opening this can of worms and then having everyone know, but there may be other people who are going through the same thing.
And I've dealt with a lot of companies where that's exactly the situation.
So getting it out in the open might be a good thing.
It's a good thing for everybody else. For you, it might be traumatizing. So the exception is if the company has a pervasive history of sexual harassment and of not handling it, then you may be able to get away with not complaining and avoiding that affirmative defense because you're able to demonstrate that in all likelihood your complaint would have been worthless.
Mm-hmm.
But without that history, and I have a case now where there is a history, but without that history, if you don't complain, you're going to either have your complaint dismissed or you're going to go through discovery, you're going to be deposed, it's going to be rough on you, and then you're going to have a case lost by summary judgment.
And probably in either way, you're probably also going to lose your job.
Well, no. That's a retaliation claim.
Okay.
There is retaliation protection under both statutes, Title VII and the Florida Civil Rights Act. And the protection is really interesting because it allows a worker, and this applies to all types of discrimination, and most of what I'm saying really does apply to all kinds of discrimination. We'll talk about that a little bit later. Age, race, gender, national origin, religion, disability. If you make a complaint to your employer and it turns out what you've complained of is not either sexual harassment or a form of discrimination. Let's say it's bad boss syndrome. You complained thinking it was sexual harassment because your boss kept calling you honey and dear and sweetie, and it turns out that's not sexual harassment. And let's say the company fires you, changes your hours, moves you to another location, does something that would be construed as adverse. Then you have a retaliation claim. And the retaliation claim gets you the exact same damages as the discrimination or sexual harassment claim.
Mm-hmm.
And the retaliation claim exists even if you're wrong on whether or not this other stuff was going on. So the employer is charged with taking that complaint and making sure you're protected pending them doing a reasonable investigation. Now, sometimes that form of protection depends upon the job. Sometimes it means putting you on leave with pay, not without pay, because then now that's adverse employment action.
Mm-hmm.
Sometimes it means temporarily moving you somewhere else. That's okay.
But that's sort of like for your protection.
That's
while
right. So you don't have to deal with your direct supervisor if that's who's harassing you. Those things are okay if they're temporary and they're designed in your best interest,
right,
so that the company can complete a reasonable investigation. Okay. But if something is done to you as a punishment, you have a retaliation claim. Now, a lot of people will say to me, well, gee, how do I prove a retaliation claim? The same way you prove a sexual harassment or discrimination claim. There could be documents, there could be words that are heard by other people. There's a number of ways. So then the question I get, and I usually tell my clients this, Can we be able to prove any type of retaliation? No. Some people are really good at it, and it's hard to prove, just like any other claims are hard to prove. Some people may retaliate against you in a way that is just not going to be very easy to prove it's retaliation. You may get dirty looks. Your assignment.
So you're being made to feel uncomfortable,
Right,
and things
right.
are happening that they're probably trying to get you to quit.
That's true, and no, it cannot always be proven. I tell the people this. I'm honest about it, but if things happen that can be proven, and most of the time, if an employer is going to be stupid enough to retaliate against you for having complained, they're going to be stupid enough to slip up in how they do it. And that's where you need a lawyer. That's where you need a lawyer deposing people, cross-examining people, trying to take whatever information you have and developing it, because retaliation is just as equally against the law as is any form of discrimination or sexual harassment. But that doesn't change the fact you got to complain. You can do it in a variety of ways. You can do it with the assistance of a lawyer. You can do it in ways that are not truly confrontational, so that you can try to come across as, please help me, as opposed to, I'm going to sue you.
Mm-hmm.
But you need to find a way, either on your own or with the assistance of an attorney, to complain in some way where it can be memorialized. It can be shown that you really complained. Even if you went up to the president of the company and you complained 5 times verbally, alone in his office, you did what you're supposed to do, no question about
Right,
it.
but
it's going to be a he said, she said.
exactly.
Now, we may be able to prove that that's really what happened, but we may not. So, as a lawyer who is looking ahead to the day when I might have to go in front of a jury, I prefer my clients to do it in writing.
Mm-hmm.
There are ways to do it that are not as threatening as other ways, but I prefer a writing. Do I always insist on a writing for somebody who calls me? No. And sometimes it's too late. They've already been fired. Then you look at the facts, you weigh them, and any attorney makes a decision as to how strong of a case it is and whether to move forward.
Mm-hmm. Now, if you do get to court, does the employer have to produce the file? We've got a file on every employee.
Yes. What's going to happen is...
What's in that file? Does that have to come?
Oh, yes.
Okay.
In discovery, your attorney is inevitably one of the very first requests, and the first request for production of documents is, give me my client's file.
Mm-hmm.
I mean, if that's not one of the requests, I'd wonder about the lawyer, frankly. It's so basic. But you're going to be looking at lots of things. You're going to be looking, aren't necessarily entitled to everybody else's file, but you may be entitled to portions of everybody else's file. And I've argued those issues, in court. I mean, am I entitled to portions of everybody's file that contain complaints of sexual harassment? Judges have usually said, yes, I am. Maybe there's a pattern here. Am I entitled to documentation in the employer's file that show all confidential settlements for sexual harassment? Yeah, probably I am. So your lawyer, once you file a lawsuit, is going to do discovery. And that's going to happen before you ever go to trial. By the time you go to trial, if you go to trial, more than 90% of cases do settle. Hopefully your attorney, and the other side too, are going to have all the documentary and evidence they want, and are going to know exactly what their theories and arguments are going to be. And you go to battle. And that's just the way it is. So, sort of tidying up a little bit on that area, there's also a time limit before you complain outside of the company. There is an administrative requirement before you can ever file a lawsuit to filing a charge of discrimination with the Equal Employment Opportunity Commission, the EEOC, and the Florida Commission on Human Relations. Now, in our state, because we have a state statute as well, you have 360 days from the date of the last act of discrimination or sexual harassment to file that charge of discrimination. If you file it on day 361, there is nothing anybody can do to save you. There is no exception. It is a hard and fast statute. When you file with the EEOC, and let's say also the Florida Commission on Human Relations, the state statute says they have 180 days to process it. So you can ask the EEOC for a right to sue letter immediately, but you're not going to be able to add the state claim for at least 180 days. So typically I'll wait the 180 days and see what the EEOC has done. Once you get the right to sue letter, you have 90 days to file a lawsuit or you've lost all your rights.
Okay.
I cannot tell you how many people call my office with 67 days have gone by and it's panic mode. Don't do it. If you get a charge of discrimination, you get a right to sue, go to an attorney immediately. Mm-hmm. Anyway, we're running out of time, so I do want to say one other thing about the EEOC, and then we're almost done with sexual harassment, and we'll move on to another area next week. But I do want to say this. In the olden days, the EEOC truly did what they're supposed to do. They investigated all these claims of discrimination. These days, I tell my clients, don't expect anything. They are overworked, understaffed. The investigator your case goes to may have 5,000 cases on his desk or her desk. Most of the time, it's just they'll give you a right to sue letter whenever you ask for it, and the box that's checked is the EEOC was unable to determine whether a claim existed.
In other words, they got that paperwork off their desk.
Right. Now, if it's a case like, 5,000 people suing Walmart, yeah, the EEOC is going to do work. Mm-hmm. But if it's the normal case, unfortunately, sometimes you get investigators that really do the work, honestly. But most of the time, they're overworked, and it's not their fault. They don't have the budget and the staffing for the amount of discrimination claims they get annually. Well, we're just about out of time, folks, and I do appreciate all of you who called. I appreciate those of you who have listened. I appreciate those of you who call my office, and I hope you continue to do so. The number at my office is 772-781-8003. And initially, you'll speak with my wonderful paralegal, Cheryl. I'm giving her lots of airtime by mentioning her name. And we'll see if you have a case, and if so, we'll try to help you. Otherwise, next Friday, 10:05.
Do you want to tease what you might be bringing us next week?
Ask a lawyer. We're going to finish up very quickly on sexual harassment, mm-hmm. and then we're going to go into what happens when you don't listen to your lawyer. We're going to talk a little bit about what is mediation and how to settle cases in mediation, and then we'll figure out the next substantive area we're going to talk about maybe in a week or two.
And, of course, wherever the phone calls lead us.
That's right. Wherever they lead us, we go down that primrose path. Follow the yellow brick road.
See you next week.
Bye-bye.
This is WPSL Port St. Lucie, the talk of the Treasure Coast.